Ms. Liz Reardon. You may proceed.
Good morning. May it please the Court. I'm Shannon Liz Reardon, here today on behalf of the plaintiff servers in this case. This matter is of critical significance that's before you today. With the proliferation of wage complaints over the last years, it's an extremely important question for employees and employers throughout the Commonwealth when employees who raise allegations of wage violations are protected from retaliation. In enacting Chapter 149, Section 148B, the legislature used strong and broad language purposely to ensure that the wage laws are complied with, specifically by protecting employees who raise allegations of wage violations, even if they haven't brought formal complaints to the Attorney General's office. Employees who are likely to be bringing allegations of wage violations are among the most economically vulnerable in our society. Many of them...
I understand your position, but one thing I wonder about, employees complain all the time. I mean, that's just the nature of people and jobs. And I wonder if that can be the type of action that the statute envisions.
Well, the statute states very clearly, no employee shall be penalized by an employer in any way as a result of any action on the part of an employee to seek his or her rights under the wage and hours provision of this chapter. That's very broad language. Just as in the discrimination context, it's clear that employees are protected from retaliation for making internal allegations of discrimination, even if they haven't actually filed complaints with the MCAD. The courts
but I'm wondering, does this cover then talking at the water cooler about, you know, my pay isn't as high as hers or his and we should do something about that?
No, that's very different. Complaining that you're not making $13 an hour and you're making $11 an hour, but you feel that you're worth $13 an hour, that's not an allegation of a violation of the wage statute. What we have here in this case is servers alleging that their tips were being taken, that their tips were being stolen, that it wasn't adding up, that there was something illegal going on here. The discrimination context as well, the courts are able to draw those lines. Many employees complain that things happen in the workplace that are unfair. There's nothing that protects them from retaliation for making those kind of complaints. But if they go over the line to complain that an action is discriminatory, then they are protected.
As I understand the statute, maybe I'm wrong, but at least your position as to the statute, the complaint doesn't have to be made solely to the Attorney General. It can be made to, as I think it was in this case, to people who administer the restaurant. Am I right?
Yeah.
And what's the statutory language that leads you to that conclusion?
It's the broad, excuse me, it's the broad language that I just read, that no employee shall be penalized by an employer as a result of any action on that employee's part to seek his or her rights under the wage and hours.
I thought there was other language somewhere in there about making complaints.
And then the second paragraph, that's the first broad language. That was enacted in 1977.
So what about the complaint language?
The second, and then in addition, the legislature added the paragraph, any employer who discharges or in any manner discriminates against an employee because such employee has made a complaint to the Attorney General or any other person.
There you go, or any other person.
Yes, that language reemphasizes that it doesn't have to be a complaint to the Attorney General.
And here they made complaints, as I understand it, to their supervisors.
Yes.
And which ultimately, I guess, filtered up almost to the top or maybe to the top echelon of executives, right?
Yes, that's correct. And now the defendants would say that because that the legislature couldn't have meant that any other person could possibly mean the employer because that would lead to absurd results. If the court were to look simply at Chapter 149, Section 150, which is the civil enforcement provision for this and other provisions of the statute, the legislature knew how to say that the filing of a complaint with the Attorney General is required for something. The second paragraph of Section 150 describes how an employee may bring a civil action after the filing of a complaint with the Attorney General. That language is much more specific.
If it's not to their supervisors, or if they're not covered and the executives who run the restaurant, who else would any other person be? The Boston Globe, the Boston Herald, who would it be?
Well, the Massachusetts Restaurant Association, in its amicus brief, claims that we're claiming it would be anyone. It would be one's dry cleaner, one's high school basketball coach. Perhaps if those people had anything to do with
Well, it's gotta be
controlling
somebody who-
employment.
Let me
but
put it this way.
we're not going that far.
We don't have to reach the outer limits because there's no question that in this case it was to management, correct?
Correct.
Okay, so I don't know about basketball coaches and I don't know about your fellow workers. Is there any question that it was to management?
There's no question it was to management. And there should be no question that to any other person in the second sentence would not include to management.
Well, let me ask you the sequence here, because I was a little confused reading these briefs. When was the complaint made to management?
The complaint was made to management.
In the record, what is it? When's the complaint made?
Well, the restaurant reopened in November 2001. The plaintiff servers were hired then. Shortly afterwards, a number of them had questions, concerns, complaints that they believed the tip law was being violated.
Well, questions,
They began
concerns,
complaining
complaints. When were they communicated to management?
Almost immediately, in November and December. One of them was then terminated in December.
When? Almost immediately. What does the record say? What do the witnesses say as to when they communicated?
The witnesses say that when the restaurant was opening, there were meetings discussing how the tip system was going to operate, and the plaintiffs did not believe that the tip system was legal. And then when they started getting their paychecks, they saw that they were only getting half of the tips that they had actually taken in for the customers, and they were asking questions at meetings and saying, how can this be? How can I only have half of my tips? And they were immediately complaining to their manager, saying, something's not right here. The tip law is being violated.
Mr. Reardon, the question we have to answer today is not whether there was retaliation. The question we have to answer is it a prerequisite that you must file a complaint with the Attorney General, correct?
Yes, that's correct.
Beyond that, the matter goes back to the Superior Court. That is the only question we have to address.
That is correct.
Fine.
And clearly, management is in a position to rectify any problem that might be a violation of the law. They could say, we'll look into this, and they could say, hey, you're right. We've got to, do something a little differently here. So management, logically, to me, has to be included in that any other person phrase.
That's correct. And also, this interpretation is in everyone's best interest. It would be an employer's best interest not to have a rule that encourages and indeed requires employees to make a formal complaint to the Attorney General's office as soon as they suspect that there's a wage violation. Instead, the result that the plaintiffs press here would encourage early attempts at amicable resolution. That is exactly what the First Circuit decided when it interpreted even stricter language of the Fair Labor Standards Act. That anti-retaliation provision requires that an employee must, quote, file a complaint in order to be protected from retaliation, yet the court stretched and interpreted the word file
We
to
don't
include
have to
internal.
reach that.
All
I have to do is look at Chapter 148A, correct?
That's correct.
Right?
That is correct.
And I can write out the words "or any other person," or I can say, you've got to make a complaint to the Attorney General.
Yes.
Correct?
Yes. Yes, that's correct. I do want to point out that one argument the defendants press adamantly is that because this statute carries potential criminal penalties, the rule of lenity requires that any ambiguities be read in the defendant's favor. I want to stress that that only applies, first of all, when there's ambiguity, and here there is no ambiguity.
Well, there might be ambiguity as to whether or not these are complaints, correct?
I believe in the record as it stands, taken in the light most favorable to the plaintiffs, no, there's not.
I
Perhaps
understand
that is a
but
fact
that-
issue for trial.
But that wasn't the legal ruling of the court below.
That's correct.
Correct?
That is
the legal
correct.
ruling of the court below is the complaint has to go to the Attorney General.
Yes, and indeed, the court below, I believe if you read the decision, apparently stated that in a misunderstanding of what the plaintiffs were even contending. Plaintiffs The court stated that the plaintiffs contend they were terminated in retaliation for filing complaints with the Attorney General's office. However, I only see evidence that 2 of them complained to the Attorney General's office before being terminated. Therefore, the court granted summary judgment for those who didn't have the evidence, denied it for those who did. But misreading that the plaintiff's complaint and summary judgment opposition was not focused on whether they were retaliated against for complaining to the Attorney General's office. Their claim was they were retaliated against for internal complaints of wage violations. I also want to point out, with respect to the defendant's argument about the rule of lenity, the criminal provisions, the potential criminal provisions of Chapter 149, Section 148A, only apply to the second paragraph. So although the plaintiffs submit that there's no ambiguity in either the first or the second, any possible application of the rule of lenity would only apply to the second paragraph. The first paragraph, which is the most broadly written, any action on the part of an employee to seek his or her rights, there's no need to apply
Does the
rule
rule
of
of
lenity.
lenity even apply here? I thought that applied only to criminal statutes.
Well,
And here you've got a civil statute that's got a component that says, well, it may be, if an attorney general decides to prosecute, a criminal offense. Does that mean in all civil statutes that have that kind of thing tucked into it, we're going to have to apply a rule of lenity?
No, not at all. And it's
Are there
very
any
important.
cases that say this?
Well, no, the defense presses them, but it's a rule that only applies against the Commonwealth, against the government. This is a civil enforcement proceeding, not a criminal enforcement proceeding. It has absolutely no place here. I'm just mentioning it because it's an argument that's raised so strongly throughout the defense's papers.
Well, surely we wouldn't interpret the statute one way for criminal purposes and another for other purposes. If it's a question of who any other person is, we wouldn't give it 2 different glosses, would we?
Right. Well, it's not even necessary to get to that in this case because the statute is so clear on its face in any event. And when the court is being asked to look at the statute in the context of a civil proceeding, there's no need to import.
Well, if you look at the first, you're talking about the first paragraph now. I mean, I read it, it says, any action to seek his or her rights under this chapter.
Yes.
All right? That seems to be suggests some formal action to seek rights, not just discussion in the kitchen that's overheard by management, which at least one of these.
Well, first of all of the plaintiff servers complained directly to the manager, their manager, Pierre Sosnitsky, who is the maitre d' front of the house manager. But any action to seek his or her rights, the first logical action that any employee would take to seek his or her rights under the wage laws is to discuss the issue with management. And because it would simply make no sense to read this in the way defendants press so as to protect employers to narrowly construe that language to say that only means an attorney general filing. And that's why I raised the comparison with the way the First Circuit has interpreted
as you know,
FLSA.
the employer takes a position that this was a specific amendment. It was designed to expand what had heretofore been a limited penalty limited to criminal penalties to a civil penalties, correct? And therefore, at minimum, you read the other person as somebody in the government, correct?
Well, that's what defendants would claim, but there's...
Well, they're looking at the statutory history.
Right. Well, that's why I said, for one thing, you have the first paragraph and you have the second paragraph. If what the legislature meant was a complaint to the Attorney General or anyone else in the Attorney General's office, that's not what they must have meant by any other person, because look at Section 150. A complaint to the Attorney General is described there as filing with the Attorney General. It doesn't say the Attorney General or any other person in Section 150.
Right, but part of the problem I have, though, is that paragraph does go on, made a complaint to the Attorney General or any other person, or assist the Attorney General, or instituted a proceeding, or testifies in proceedings. Its whole thrust does seem to be sort of external, whereas I think perhaps your stronger argument is under the any action, which is, there's no language surrounding that sentence to sort of point us in any particular direction about how broad, where the limits might be.
Yes, that's correct. The stronger argument is under the first paragraph, but under the second paragraph, the legislature did insert the words "or any other person," which they did not insert into Section 150 to describe somebody else in the government.
True, but some people might go to, their local police or the Department of Labor or their union or,
Right. Well, it would make sense to interpret any other person to mean any other person who might have some control or bearing on the person's employment, who might be able to, in fact, rectify or help rectify the situation. Obviously, the employer is the most logical first step, and that's what the legislature was obviously intending to encourage.
Ms. Leslie, what do you do with the employer's position that what was being done here was not illegal? In other words, if an employee in any situation disagrees with how management is handling compensation, but it's not illegal, it's just a difference of opinion, and management then determines, for whatever reason, perhaps because it doesn't like the fact that its management policies are getting challenged at every level and causing dissension, in this case among the wait staff, that it is free to terminate them.
Well, there are a couple of answers to that, Your Honor. First of all, in the discrimination context, again, it's not necessary for the person claiming discrimination who has a retaliation claim to have actually correctly stated that there was, in fact, discrimination. This Court held that in Bain versus City of Springfield.
Yeah, but there's a slight difference, it seems to me, because in the discrimination context, if I say there doesn't have to be a finding of discrimination, but if I go to an employer and say, look, my intermediary boss, seems to be giving all the best assignments to the men. And, the manager takes note of that, and then, she comes back sometime later and says, I notice that the bonus system has been awarded on the basis of, the hours worked on a particular project, but I couldn't work on the hours because I was given insufficient assignments to fill up my 3,000 billable hours. That seems to me to be a claim about gender discrimination. And it may turn out on review that, in fact, the assignments were being perfectly fairly handled. It had to do with expertise or something else. But she's made a specific claim about gender discrimination, which is illegal. Here you have a complaint about the way management is handling its tips. The complaint is not about an illegal activity which might or might not be established subsequently.
But yes, it is. And in fact, the affidavit of the manager is that the wait staff were complaining that the employer was violating the tip statute. The waiters testified that they believed that the tips were being handled illegally, that their money was being taken away from them. I agree there can be a fact issue in some cases as to whether the complaint is, I'm not getting paid enough for what I'm worth, I should be paid $13 an hour, I'm only being paid $11 an hour, versus I'm complaining that this policy is breaking a law. Here, the plaintiff wait staff reasonably believed that because a manager was taking a share of their tips, because the Attorney General's office had said that that was illegal, because there were newspaper articles saying that that was illegal, they reasonably believed that that was illegal, that was their complaint, and they're asserting that they were terminated in retaliation for that. And simply because the wait staff have chosen not to press the actual tips claim in this case, because the retaliation claims, they only worked there for a short period. The tips damages don't add up to very much, but they're losing their jobs adds up to quite a bit. And because the legislature in 2004 amended the tip statute to make explicit what had previously been perhaps implicit, that managers can't take shares of tips, it was perfectly reasonable for them to believe that it was illegal at the time. And I just wanted to briefly note that this Court's decision in Swift versus AutoZone holding that the legislature's amendment to a decades-old statute to make explicit what was previously implicit is a legislative reenactment and reinterpretation of the previous statute. So although it's not before this Court whether there actually was a TIPS violation here, it is clear the legislature has determined that managers cannot receive shares of waitstaff tips, and the waitstaff reasonably believed that what was happening was not only unfair, but it was unlawful, and that's what their complaints were.
Thank you, Ms. Misleading.
Thank you.
Mr. Katz?
May it please the Court, my name is Gordon Katz, and I represent the defendants in this case. This case, which is no longer about the tipping statute, has two main parts. The first is a legal analysis of Chapter 149, Section 148A, to determine what kind of complaints are required in order to permit a retaliation claim under that statute, Section 148A.
Mr. Katz, let me just ask you about that. Do I not have a reported decision here, a reported question?
What we have, I believe, Your Honor, is a question. We have an appeal that started out with a reported question and then an order from this Court, which basically opened up
the whole thing?
The whole thing. And it's for that reason that...
But if I look at the underlying decisions in the Superior Court, wasn't the determination made that you had to file a complaint with the Attorney General?
That is correct.
So if we determine that you don't have to file a complaint with the Attorney General, right, okay, then we look to see whether it's clear for purposes of summary judgment, which is reading the record and the like, most favorable to the employees, correct?
Correct.
That there has been, as a matter of law, no complaint? Or
no, what we would do, and this is what we've argued in our brief,
right,
and this is the second question.
No, I understand.
That we would get to is, and it's our position that regardless of which standard you take with respect to Section 148A, if you look at the record, you will find that there is insufficient evidence to go to trial. And for different reasons. And I'm happy to address, that's one of my later arguments, but I'm happy to address that now, that even if even if internal complaints to the employer were sufficient, which I strongly disagree, to get over the 148A hurdle, there is not enough evidence of causation, if you will, to establish that these individuals were terminated as a result of those complaints for there to be a trial.
Did the judge make that determination?
The judge did make that determination, and we believe
which
erroneously.
The first Superior Court judge or the second Superior Court judge?
The first Superior Court judge, Judge Staffner Holtz.
But I thought that the basis of her ruling was you didn't file a complaint with the Attorney General.
The basis with her of her decision was, and keep in mind, we're the employer. We didn't file complaints. But there were initially, and there are now, 4 plaintiffs. 2 of them filed complaints with the Attorney General, and she ruled that their claims could go forward.
Correct.
We believe that was an error. There were 2 other plaintiffs who did not file a complaint with the Attorney General, and it is with respect to those that my sister is appealing. If Your Honor were to permit those 2 to go forward,
right,
in addition to the other 2, we would still believe that all 4 of them lack sufficient evidence, based on the record that's before you now, for their retaliation claim to go to trial.
Okay. Now, is that on the basis, are you conceding only for purposes of summary judgment, okay, only for purposes of summary judgment, that there was a complaint and there was a complaint to management?
We will.
Or you're saying no complaint, and if there was a complaint, it wasn't to management, and if it was to management, there wasn't sufficient nexus between the complaints and the termination.
Your Honor, you raise a very good question, because this issue did not come up in the questions to my sister. The question really is, what would a complaint to management be?
No, I understand that, but I just want
to... We would say that even though there were oral communications from the servers to Mr. Sosniski, there were not complaints in any cognizable form that could permit action under Section 148A. And the reason I say this is
Well, one of the things you say is they have to be in writing. There's nothing
Correct.
that suggests to me that they have to be in writing.
Except the Valerio case. If you take a look at the Valerio case,
No,
the
no, I
the
understand.
First Circuit case, the Valerio case dealt with an issue that was somewhat related to this. In fact, it dealt with the notion of complaints.
You cannot tell me that if an employee goes to the Attorney General in person and speaks to a representative of the Attorney General's office, that doesn't constitute a complaint. You're going to have a hard time persuading
And that's
me.
not the point, Your Honor.
Why?
We do concede that. We will
Then
concede
why
that.
do I apply a different standard when it comes to management, assuming that you don't win on the first
Because
point?
because it's a matter of proof, and it's a matter of there being a situation, as I think we have in this case, and we could have in virtually any case where you have a terminated employee. Terminated, and
That's a jury question, isn't it?
It could be a jury question, but I suggest to you, Your Honors, that it is a consequence of such magnitude that you should consider it when you're determining the interpretation of the statute. Consider this hypothetical. We have a small family-owned restaurant that is subject to the wage and hours laws. They have a server who works, say, some period of time and is terminated for poor performance. The terminated employee, and there's no record of this. It's a small family business, and they don't keep records of all communications, and there was no written
But,
documentation.
Mr. Katz, you're missing the point. You
Well-
have to file an affidavit that says, I told X. Now, you may file a counter affidavit saying, you never told X. I mean, X may say, the employer may say, you never told me that. But you keep going back to it's not in writing.
Well, let me just continue the hypothetical and tell you where the rubber meets the road. Employee has been terminated. There's no written complaint that predated the termination. She finds a lawyer, brings a lawsuit,
Right.
and claims that she had made an oral complaint
Yes.
prior to the termination, and claims that she's entitled to retaliate. She's entitled to a cause of action under the retaliation statute.
Right. Same for sex discrimination.
The result is not only is the employer subject to the massive civil penalties under under Section 150, and their treble damages and attorney's fees, and the costs that go with defending yourself, the employer is also subject to the criminal penalties.
Only if there's a finding.
Yeah.
Under Section
Maybe-
27C.
Maybe
Only
he ought
if
to
there's
be.
a finding.
If a fact finder finds that a strenuous complaint was made verbally to a manager who had authority to deal with it and who should have been trained and perhaps instructed in advance to be alert to these kinds of things under the wage and hours law, and a fact finder, as was just said, finds that the complaint was made and it was sufficient to put them on notice, maybe he ought to be subject to all these penalties.
But I will suggest to you, Your Honor, that under the law of this Court, that if oral complaints were permitted as either constituting basis for liability under the first section or the first paragraph of Section 148A or the second paragraph of 148A, that would have constitutional implications. And it would have constitutional
Wait.
Have
Mr.
constitutional
Katz, wait.
implications.
I mean,
The reason for it, if I could finish, is that if the statute were to permit oral complaints as a basis for prosecution, it would have constitutional defects because it will not have given fair notice for that prosecution.
Mr. Katz, to my knowledge, unless you haven't given me a citation to the Constitution, you haven't raised that argument.
Well, I think we did. I think it's related to the issue that when you have criminal penalties,
No,
you have to look at the statute narrowly, and you have to look at the statute from the standpoint of the defendant, and in this case, the defendant employer.
But there's no defendant here.
Yeah.
Well, we're the defendant.
There's no government action.
And we're the potential defendant.
Yeah.
And as Justice Cordy alluded...
Have you got a case that says in this kind of context where you're dealing with a civil statute that allows a civil lawsuit and then has a criminal component that the rule of lenity applies?
I have a case which says, as Justice Cordy suggested, that when the statute has both criminal and civil penalties, you interpret the statute the same. There may be different burdens of proof, but the statute that you would look at or the case that you would look at is a Supreme Court case that...
That's all right. If it's in your brief.
That I can give you the...
It's in your brief, right?
It is not in our brief because the issue only came up in the reply.
Okay.
But so let me give you the case right now,
Or you can send it in a letter.
and I'd be happy to do that, and that's probably a more efficient use of time.
Let's do that.
Mr. Katz, I want to go back to what we're deciding here. It seems to me that that ultimately, if we don't agree with you on the fact that there has to be a written complaint, and I understood your argument, there has to be a written, at very minimum.
At a minimum.
At a minimum, there has to be a written complaint. That there wasn't sufficient nexus here between the failure of the complaint and the termination. That's what I would like you to address. In other words, I know you're talking about
Yes.
it's got to be the Attorney General, this wasn't management, it's got to be in writing, but I just want to find out about the nexus.
Right. If the point is, if the law
Because
is
you're looking
that
for,
that
you're
internal
looking for
complaints...
summary judgment,
Right.
right?
If internal complaints are satisfactory...
Okay.
We believe that the Superior Court's order should be reversed and all retaliation claims dismissed because there's insufficient evidence that any of the 4 plaintiffs were terminated for anything other than poor performance on the job.
Well,
And
my question would be, why wouldn't that be a jury question then? Because you have evidence, as I've read your briefs, that there were valid reasons for firing each person, and they may be. But then why wouldn't it be a jury question?
And that's the right question. Let me tell you the answer to it. The answer is in the record. If you take a look at the record carefully, as they did in the Valerio case in the First Circuit, you'll find that Mr. Sosnitsky, at his deposition, gave a performance-based reason for the firing of each of the servers. For Plaintiff Smith...
But we've got to take them in the light most favorable to the employee, correct?
Yes, but
So tell me, in the light most favorable to them, how I look at this record.
Well, in a sense, they have no evidence on tying up their complaints to their termination. What the judge at the Superior Court did was utilize the rule from the Mole case, which permitted an inference of retaliatory causation where there's a temporal proximity of complaint and discharge. But that inference, I submit, is not applicable in this case, because Mole permits an inference of causation only if, using the words of the court, adverse action is taken against a satisfactorily performing employee in the immediate aftermath of the employee's protected activity. It is not disputed.
Can you tell us how much time passed between the time they complained and the time that they were discharged?
Well, at least a month. And according to what we heard this morning, the complaints took place immediately. We know, and this was November 2001, we know that 2 of the servers were fired for performance reasons in December of 2001, and we know that the 3rd was fired in January of 2001, and then Mr. Sosnitsky, who doesn't have a claim under the statute anyway, for reasons that we discuss in the brief, and I'm happy to go into, was terminated either in February or March, again for performance reasons. This is of 2002. So,
Mr. Katz, help me out here. It's not the same. I understand it. It's not the same. But we have, a gender claim, a sexual harassment claim. The former employee, she says, I complained about my, my intermediate supervisor harassing me. And I was fired a month, 2 months later. And the employer comes into court and says, one, that doesn't constitute a complaint, but second, let me tell you why she was fired. I don't think, in other words, she didn't show up on time, she was disruptive in the workforce, whatever it is. I mean, perfectly legitimate employer reasons. Doesn't that go to the jury?
Your Honor, I think the key difference in the 2 situations does come down to the criminal nature of the statute, which I urge you not to minimize. Section 27C criminalizes everything in Section 148A. And this was done in 1998.
But doesn't it
And
only...
that makes it, that, I
But doesn't
think,
it only criminalize it if there's a determination that, in fact, there was retaliation?
but I think this comes to the issue of how do you establish, for purposes of 148, whether the requirements for retaliation have been met? How do you interpret the terms, which are the subject of this appeal? And I submit that because of these criminal implications, which are extraordinarily strong, whether they're utilized or not, they are there and they could be used, you must, pursuant to the laws that have been established by this Court, interpret this statute narrowly. You should use the principle of the just and generous. You should also take a look at the Equal Pay Act, the Massachusetts Equal Pay Act, which we haven't talked about, but which is discussed in our brief, which distinctly says that complaints must be to the employer. This wasn't done here. The legislature was certainly aware of it. And when you put all of those concepts together, particularly, again, I can't emphasize too strongly, the criminal nature of this statute must be interpreted narrowly. It's not like any of the other retaliation statutes which have been discussed in the briefs.
I have a further question about your summary judgment argument. You said that, I want to be sure I understand it, you said that Moll permits an adverse action against, the inference of an adverse action against satisfactory employees.
Correct.
And here, all your evidence you say is that they weren't satisfactory, so you don't get the inference of adverse action. But is there anything in the record that would make it a fact question whether they were satisfactory
No.
employees?
See, that's the key point that I'm making, Your Honor, is that point is undisputed. Mr. Sosnitsky, who is all the evidence in this case, he's their witness. He testifies with respect to each of the three terminated employees that he terminated them at a particular place, at a particular time, because they did particularly poor performance activities. In one case, it was a server, that's Smith, who was lingering in the kitchen after having been repeatedly told not to. In another case, Porter, the issue with him, in his words, was lies. He was lying to me, and he couldn't tolerate that, fired him. Third case, Kimball. Kimball didn't show up for work. He was terminated. All of those situations, I think, when you read the record carefully, will convince you that these individuals were terminated because of their performance. The complaint, which was oral, was, in the case of two of them, was never made to the Attorney General. In the case of the other two who did make complaints to the Attorney General, those, as the plaintiffs themselves admit, were not done openly, and there's no compelling evidence, there's really no evidence at all, that the management at Lockover's, Mr. Licari, was ever aware that these complaints had ever made.
Well, unfortunately for your client, Mr. Sosnitsky, might be management for one purposes and not for the other. Correct?
Obviously
I would
correct.
disagree in this situation. I would say in this situation he fairly clearly was not management because the decision to terminate by his own testimony was that of Mr. Licari.
Okay. Thank you, Mr. Katz.
Thank you very much, Your Honor.
We'll take a short break.
All right.